We got a lot to talk about right now, gentlemen and ladies and gents. We're going to talk about the petition for the writ of habeas corpus. Now again, you'll have to do your research, but a writ of habeas corpus utilized in one unique situation. What situation is that? That situation that a writ of habeas corpus is utilized in is when you are deprived of your liberty. Now a lot of people don't understand, don't get it, don't even comprehend it. That's their fault, because ignorance of law is no excuse. Not today, not yesterday, not even someday. Okay? Give me 1 second. I don't like this song. I don't even know who it is. Who y'all be? I don't care about somebody wanting somebody's number. Oh, this is New Edition. Yeah, we're gonna get Crump tonight or something like that. I know the song, I've heard it before, but I'm not a big fan. Sorry. Alright. Most people don't understand what's going on with the Constitution, so what we're gonna do is we're gonna stop this right now. Stop it! What are you doing? Stop it! We're going to open up that, if it opens, because the last time it didn't open, y'all. So we're gonna open that up and we're gonna see what it says. So give me a second so this stupid thing will open up. 1 second. Okay, ladies and gentlemen, there are a couple of things to bring to your attention. We highlighted this one previously. Look at that. Ain't even doing what it's supposed to do. But anyway, we highlighted this one previously, and so this is what we're going to show you. We're waiting for it to catch up, and it's almost there. Alright, we got the debts, and supremacy laws. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid as against the United States under this Constitution as under the Confederation. This comes from, pay attention, because a lot of people don't get it. This comes from the Northwest Ordinance. That statement right there. Because why? Every constitution that was created after that had to comply with the Northwest Ordinance. Okay? This is not supposed to be playing new edition after new edition. It's supposed to be shuffling. Yeah. We're going to let that play. I got to get rid of this because I didn't open that. So that's got to go. Alright, let's get back to this so that you guys understand something. This Constitution and the laws of the United States shall be made in pursuance thereof, and all treaties, and the laws of the United States shall be made in pursuance thereof, and all treaties made, or which may be made under the authority of the United States, shall be the supreme law of the land. Ladies and gentlemen, this Constitution is only the supreme law of the land when it's made in pursuance to the original treaty. What was the original treaty? The Northwest Ordinance. That was an agreement between those original colonies. Nobody paid attention or recognized. It was just called the Northwest Ordinance, but it was a treaty between those states. Okay? Okay. The judges of every state shall be bound by all treaties. Northwest Ordinance. Okay? Alright. Now, got that going. I got one more thing I need to show y'all. This ain't the full Constitution. It's just all of that junk. But we need the 7th Amendment so you guys can understand the reason for your habeas corpus. Hold on. Uh-oh, didn't want to do that. Let's put it back. Whew, almost messed up. I need my hand. Can I get my hand? Can I get a hand? Okay. In suits at common law, where the value in controversy shall exceed $20, the right to a trial by jury shall be preserved. In other words, preserved and reserved. And no fact tried by a jury shall be otherwise re-examined in any court of the United States. That includes the Minnesota Supreme Court, the District Court of the State of California. Then in accordance with the rules of common law. The rules of common law does not allow an administrative venue to re-examine a common law case. And no facts tried by the jury. What was one of the facts tried by the jury? That what the banks did not constitute consideration. Okay? Congress would now have to come in and make a law that says that it does, and they have not. I tried to tell all of you. Again, Credit River has not been overturned because it cannot be. Again, trial by jury shall be preserved. No one could stop that. This is where the judge said they had no jurisdiction. Why? When you hear about original jurisdiction, it's talking about common law. That is the original jurisdiction. That's why you see common law mentioned here and rules of common law mentioned again. The reason why it mentions common law twice and jury trial twice is to solidify that right. Okay? And because what the jury got to hear in the Credit River decision were facts. You don't believe me? Go back and listen to the judge's memorandum and the actual decision in the case where the jury got to hear the facts. And the parties got to introduce all of their evidence. The jury heard both the evidence and facts. When the court say they get to determine the facts, and you pull up this and say, oh no, you don't get to determine the facts. The jury gets to determine the facts. You, if you're on trial, you get to show this to the jury and say you get to determine the facts. This person has no authority to determine the facts because the law has always held that the jury determines the facts. You cannot go to the judge and ask the judge a question on the facts. You are not ignorant of law, are you? You cannot use this person as an attorney and ask them legal advice, and every jury that asks the judge a question, puts a question before the judge, is asking the judge for legal advice and cannot do that. Sorry. I apologize. Some of you are going to get what I just said. Now, this song by Mary J. Blige, How She Ain't Gonna Cry, She Not Gonna Shed No Tears. Let me tell y'all something. This song has a lot of meaning to me. Okay, ladies and gentlemen, so that you get the fact about habeas corpus, hold on, let's go to the habeas corpus section. No, what am I doing? Hold on. Let's do... All right, the privilege. You see how they use the word privilege? Habeas corpus is not a privilege, people. Habeas corpus is a right. And if you take a look at the Northwest Ordinance, you'll see that habeas corpus is a right. Do you see, unless when cases of rebellion and invasion to the public safety may require. You bring habeas corpus under the Northwest Ordinance. But let me make sure you understand, what does habeas corpus mean? Did anybody know? Everybody, anybody? People say it's usually when a person is in prison. That's right. It's usually when a person, pay attention, it's usually when a person is imprisoned. However, it means if you're in prison that you're being restrained of your liberties. So the Supreme Court has ruled that a habeas corpus may be used by persons who are even on probation. Ladies and gentlemen, hold on. I need to show you guys something else. Ex post facto laws shall be passed. It says no bill of attainder or ex post facto law shall be passed. Did it say anything about civil law? Did you see anything about civil law? Did you see anything about criminal law here? Well, the courts have interpreted that this only applies to ex post facto laws referencing criminal laws. No, this says no ex post facto law shall be passed. So why are they getting away with it? Because people are not challenging their presumption. When Congress said no, that left no room for yes. I know there are no guarantees. In love, you take your chances. Anyway, I'm kidding, morons. All right, let's get back to servitude. I don't have to do the hard word. Oh, I said V. Oh, there is. Uh-oh, that's a Y. Okay. Neither slavery nor involuntary servitude, and don't worry about the except. Do not worry about that. Shall exist within the United States or any place subject to their jurisdiction. Ladies and gentlemen, no involuntary servitude. But remember, you need to volunteer to be placed into their jurisdiction. Well, if you didn't volunteer, then you need to be doing a habeas corpus, saying that someone has subjected you to slavery and involuntary servitude in violation of the 13th Amendment of the Constitution. You see, this thing, slavery abolished, this has nothing to do with the abolishment of slavery. That's why they redid it in 1865. It was already the law according to the Northwest Ordinance. But neither slavery nor involuntary servitude shall exist within the United States or any place subject to their jurisdiction. Look, it says except as punishment for a crime whereof, now you know, for a crime, that ain't even proper English, is it? Whereof a party shall have been duly convicted. How do you get duly convicted? Because you sit there and you agree. Remember, neither slavery nor involuntary servitude. Okay? Just want you to understand. So, your remedy is habeas corpus. Somebody's trying to take your home away. Isn't that subjecting you to involuntary servitude? Taking away your right to own property? Remember, this is not a privilege here. It is not a privilege to be a slave. You have a right to be in servitude if you volunteer. But if you did not volunteer, they don't have a right to hold you in servitude. Ladies and gentlemen, that means that you will have to start doing habeas corpuses. Those of you who want to achieve the age of majority, you're going to have to do a writ of habeas corpus saying that the acts of Congress, mainly the, what's that stupid act? March 9, 1933 Act, the Trading with the Enemies Act. What is the other act that is so damning? The Social Security Act, the Housing Act, all of them. That these acts, including the Administrative Procedures Act, and, got one more, the presumption of law theory. Because presumption of law is a theory. That's the theory that says that anything somebody says, if you don't rebut it, becomes a fact. Sorry, justice does not recognize such a thing, where somebody comes up with an idea, and that idea becomes fact just because the other person said it and nobody challenged them on that. You guys often, if you read scripture, if you read the book of Proverbs, you see that if a fool is talking, you let that fool keep talking. You don't argue with a fool. So how could presumption of law ever be fact? So you have to challenge presumption of law and you have to challenge their jurisdiction. We got one more thing. F. Okay, now we do. I just put in their original jurisdiction. Pay attention. Want y'all to pay attention. Okay, trial by jury, original jurisdiction, jury trials. Look, ladies and gentlemen, which one do you ask for? Do you ask for a trial by jury? Well, that's a criminal case. They're going to tell you that. And jury trials are in civil cases. I just know that that's what they're going to say. Okay, pay attention. I want you to see this. The judicial power shall extend to all cases in law and equity arising under this Constitution and the laws of the United States and the treaties made and which may be made under their authority, and to all cases affecting ambassadors, public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states and between a state and citizens of another state, between citizens of different states and between citizens of the same state claiming lands under grants of different states, and between a state and a citizen thereof or foreign states. Wait, hold on. And between a state or the citizens thereof and a foreign state, citizens or subjects? This section, in parentheses, is modified by the 11th Amendment. Okay, what we're focusing on, because that's not original jurisdiction. That's just that they shall have jurisdiction over all of those. Let's focus on original jurisdiction. In all cases, infected ambassadors or other public ministers and councils and those with which the state shall be a party, the Supreme Court shall have original common law jurisdiction. Okay? When you have the word original jurisdiction, that denotes common law jurisdiction. Interesting, ain't it? In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to land, a law and fact, with such exceptions and under such regulations as the Congress shall make. A trial of all crimes except in cases of impeachment shall be by jury. Trial by jury. That's the first one. Hold on. Let's do that. Let's go back up so you can see that I know trial by jury. Told you. In criminal cases. And the trial shall be held in a state in which the crime shall have been committed. But when not committed within any state, the trial shall be in such places and or places as Congress may by law direct. Interesting, ain't it? All right. Remember, nothing in the Constitution permits and allows administrative courts. The administrative courts are under the executive branch. They have a right to do that. But any court, somebody tried to tell me that a Article 1 court was a constitutional court, was a actual court of record. Ladies and gentlemen, Article 1 court is not a judicial court. Okay? If you go back, got my hand going, I gotta make the screen smaller so we can go. Okay, won't let me do that. Mariah, tell them please. Judicial power. This is what we're looking for when you're looking for a thing. Pay attention. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. What other courts have Congress ordained and established? Excuse me? Does anybody know? Well, they did the District Court of the United... Well, they actually did the Circuit Courts of the United States. So you remember, the judicial power of the United States shall be vested in one Supreme Court. So it will be the Supreme Court of the United States, not the United States Supreme Court. Because the judicial power is in the court of the United States, not the United States of that court. The United States has the power, so the court has to be under the court. So the judicial power of the United States, not the judicial power for the United States. And not Supreme Court, the United States Supreme Court, because that would make the Supreme Court the superior. Notice how supreme is lowercase, court is capitalized? Ain't that interesting, huh? So, ladies and gentlemen, what I'm going to suggest, because I have a meeting that I have to attend, is that those of you who are trying to get yourself separated, habeas corpus, you bring forth your habeas corpus on the fact that your liberties are being constrained. Okay? That you're being held in servitude without contract. And you have to rescind all contracts made during infancy. Okay? I would strongly suggest that those of you who are a little bit more mentally, legally wise, that you give that some thought about doing a habeas corpus in order to get rid of the shackles and the chains. Remember, the slaves were allowed to do the same thing. They were allowed to bring forth habeas corpuses when they were being held in slavery. That's what you use as your premise. Okay, it's as long as your, pay attention, freedoms or liberties are being constrained, restrained. Gotta go, ladies and gentlemen. I hope this helped.